States versus Chapman coming up next.
Yeah.
That is case number 18CA011377. Just like the last case, you'll have 15 minutes to argue. You may reserve up to 5 minutes for rebuttal. We've read the briefs and are ready to proceed.
Thank you, Your Honors. Again, may it please the court, my name is Giovanna Bremke on behalf of London Chapman. So we're going to be repetitive arguments of Mr. Anderson's case, but for the record, I will proceed. Again, there's 3 issues raised here. Well, 2, but the first is broken down into whether this condition of probation, meaning to make all reasonable efforts to not impregnate a woman during the community control period, whether that is, whether it meets standards under non-constitutional grounds and under constitutional grounds, and then also a restitution issue as far as restitution incurring during the indictment period. So under the non-constitutional issue of this provision, again, some of the non-constitutional issues have been addressed previously by this court in the same case prior to being remanded, and then also by the Supreme Court in Talty, but not totally exhausted of the non-constitutional issues. In Talty, there's reference that they didn't address all of the non-constitutional or the constitutional grounds because of the lifting mechanism being overly broad. So in this matter, again, from the prior London Chapman case when it was before this court, there has been an expansion of argument that the issue of reasonable efforts is overbroad, that whether what constitutes reasonable efforts, meaning sterilization, protection, abstinence, does this completely strip Mr. Chapman's rights to have sexual relations completely? And again, it's overly broad. It doesn't meet the non-constitutional standard under the Jones case. The constitutional issues, again, there's no dispute, I don't believe, by the state, by the trial court, by this court, by the Supreme Court, that procreation is a fundamental right. Fundamental rights have to be viewed under a strict scrutiny standard and be narrowly tailored to meet a compelling state interest. So the trial court judge in this matter issues a lengthy decision on the constitutional grounds and cites several other fundamental rights that are limited during a probationary period, such as the right to bear arms, the right to travel, the right to association, the right to, he has a whole list of them, some First Amendment rights. And the difference here is that this provision explicitly requires another individual. So it requires another individual, and it's stripping that individual of their rights to procreate with Mr. Chapman should they desire. The court also addresses the burden on the taxpayer, essentially saying that there's you don't need another mouth to feed. The burden doesn't need to be on the taxpayer to take care of these children that you are creating. And again, there's California cases that have addressed the issue that a burden on the taxpayer to provide for children is not a compelling state interest. There's also the restitution issue, and again, this was objected to and is new since the last time that these issues were addressed in this court, but that the restitution, what happened in this case is there's a restitution order previously during the first sentencing period. The arrears, the amounts continued to accrue, and then there was a new restitution amount, which included times outside of that indictment period. So there, in the indictment, there specifically has a period of time where there was non-payment, and this court has previously addressed it, but I'm asking that you readdress the issue again, because the issue here is non-support during that window of time. and whether, and that's what restitution is. Now, there's no doubt that there's an underlying support order, and that those arrears are owed, but not restitution in this case. And the reason second to that is that the trial court and the state don't break up what are arrears and what are restitution. And I think that's significant because should Mr. Chapman be able to pay restitution in this case, meaning during that period of time where he's indicted for non-support, he could pay off the restitution in this case, potentially. That's obviously a factor in being released from probation. But now he's strapped with paying his arrears plus the restitution amount in order to be relieved from his probation obligations. If there are no questions, I reserve.
Okay, you have 5 minutes for rebuttal.
Thank you, Your Honors. So I'll introduce myself just for the record again. Jennifer Goodall on behalf of the state. I am also going to kind of fast forward through the issues because you've already heard them. But before I get there, I want to make sure that there are a couple things that have come up that I don't forget to address. So the court had previously inquired on the issues as whether or not there was a situation where the defendant could petition the court for release from this condition that were in his control other than proving that he was supporting his current children. And I think the court kind of gave me that answer. So there are circumstances wherein he could plan ahead to want to procreate, but also that procreation would be paired with a situation where he does not need to provide support because his failure to support his current children and obtaining or being burdened with additional financial obligations is primarily the court's concern in his conditions of community control and in his sentencing. The court wants to ensure that he is going to pay this support order, which is the reason that he was convicted in the first place, because he wasn't. So if he can present a situation to the court, ask permission to procreate in this situation, and pair it with him not having to pay support, then the court would probably give him permission to do it. A sperm donation is a perfect example of that. A surrogate where he's donating sperm to procreate with a woman for someone else who can't procreate would be another situation, because in those situations, the person that's providing the means to procreate is contractually not bound to provide child support, to not support that child. So if he really wants to procreate, then those are situations he could present to the court and say, look, this is what I want to do, and the court would probably give him permission to procreate in that scenario. So it all goes back to the fact that the court wants him to be successful in community control. They want him to pay his current legal obligations, and part of those current legal obligations are his arrears order. So if the court's ordering him to pay his arrears in addition to the amount that's due during the period of the indictment, that is a separate obligation that he has legally anyways, and the court's just ordering him to do what he's already supposed to do. They're not giving him an additional obligation. So that goes towards the last issue of the arrears, but it's the arrears themselves are not an obligation the court's imposing upon him that doesn't pre-exist him being placed on probation. Also, the issue of procreation needing two people, it's the state's position that the defendant doesn't have standing to raise a non-party, non-existing individual right now, their argument with regard to their right to procreate with him. It's his right to procreate with someone else that we're addressing, and that other person that he wants to procreate, to the state's knowledge, doesn't exist right now. And if that person did exist, that would be another situation where he could bring it to the court and say, look, I have a significant other, I have a partner, that partner is economically self-sufficient, she does not want me to support this child, she's willing to waive any support that I have to give to that child. So perhaps he falls in love with the billionaire and they never ever need him to provide any support for that child. The court would probably say, okay, you can procreate with this person as long as these conditions are met.
Well, she can't waive the child support obligation.
She can also forgive.
It's one of the lifting mechanisms. The attention to the lifting mechanisms, though, is because other than the payment of the support, I don't see anything else on that list under which he has exclusive control. Right?
Well, the first two that I gave you, with that you actually gave to me, which was surrogacy and sperm donation, he has control over. Those are situations that he would be procreating, that he would voluntarily enter into, that he would not have to support the child.
Right, that's about whether or not he's going to be in violation of this, but I'm talking about the lifting mechanism for the order.
So the order itself would be lifted for the purposes of that procreation.
We're not making a connection.
Okay.
And I might not, maybe when we're talking about the lifting mechanism, and I'm talking about getting successfully completing community control or probation. Old language, but the only way he can successfully complete community control is by paying the support and the arrearage, right?
No. The arrears does not have to be paid in full for him to successfully complete community control. He just needs to comply with the current order during his period of probation, which includes a partial arrears payment every month that goes credited towards the arrears.
And if he can't do that, and as it relates to the arrears, the condition's never lifted during the term of his community control.
So he can maintain an arrearage. It would be the state's position that he could still have an arrearage that he's paying on, and he could also still be in a situation where he could petition the court for that mechanism to be lifted.
But the court listed in its non-exhaustive list, pay the arrearage.
Right. So if he were to do that, that would be a situation where he could go to the court and say, look, I can do it, I've done it. But that's not, all of those things don't have to happen in order for the mechanism to be lifted. They're just options where he could come to the court for it to be lifted.
Here's a question for you. One of the conditions is the child becomes emancipated. Say all 6 of Mr. Chapman's children become emancipated, and now all he has is arrearages. He doesn't have any order for current support. At that time, could he petition the court to say, hey, I want to have some more kids?
Clearly, the trial court thinks so. I mean,
There's no current order for support because the children are all emancipated.
right.
So he still
So
has
there's
the
only an arrears
arrearages.
order.
They're not going to
So
go
the
away.
order that he would be paying would go to the former custodian, and the children themselves would no longer need to be supported on a daily basis because they're of age and capable of supporting themselves. So his failure to pay his monthly obligation at that point would be a failure to pay an arrears order. And so it's at least the state's position that the court is most concerned with his ability to pay his current child support. So that child who still needs to be supported with food and shelter and clothes and education and everything else, that they have what they need during their minority.
Here's another hypothetical. Say mom remarries and stepdad adopts all 6 of those children. Does that meet number 1 adoption? He still has arrearages, but he has no current responsibility to pay for any one
I
of
think
those
it
children.
probably does, if for the same reasons that the emancipation does. So, all right, I'll summarize really super fast, just so it's on the record for this case. So there's the non-constitutional argument. The state's position is that that was disposed of the first time around, that it does meet the Jones test, that it is not overbroad because it has a lifting mechanism, and that the defendant's arguments with regard to the reasonable efforts being overbroad are not overbroad because in the law, it's pretty common that in a reasonable effort situation, if there's a challenge to the behavior, whether it's reasonable, the court uses a reasonable person test. And so that would be the situation if there were to be a challenge to his behavior to determine whether or not it was a violation of the condition of community control. So with regard to the constitutional argument, the standard test is a compelling state interest. The restriction must be narrowly tailored to meet that state interest, and that it's reviewed under strict scrutiny. And those are the rules and the standards for restriction or impingement on fundamental rights. Procreation is a fundamental right. This situation is different in that it's a restriction on a fundamental right by a probationer or a person who's previously broken the law. And both the Ohio Supreme Court and the United Supreme Court, in the cases that I cited in my brief, have stated that fundamental rights can be restricted, that the trial court judge has broad discretion in determining conditions of community control that impinge upon fundamental rights, and that supervision itself is a condition, is a special need of the state. And so, finally, that probationers only enjoy conditional liberty, not absolute liberty, like regular citizens during the period that they're on probation. So we believe that that the probation itself is the compelling state interest, that probationers' rights may be impinged upon, and that they perhaps don't need to, the conditions upon them may not need to be so narrowly tailored to that state interest. And additionally, based upon the Ohio Supreme Court case in Jones, that a review of those conditions that impinge upon fundamental rights should be reviewed under an abuse of discretion standard, not strict scrutiny. We believe that the trial court, because it went through it in length, examined the applicable law, how fundamental rights can be restricted, what rules need to be followed, what standards are used, and very carefully and thoughtfully crafted this condition, this restriction pursuant to that. And that the Ohio Supreme Court, in its Talty decision, references the Oakley decision from Wisconsin, and crafted this in a way to mimic that, so that it would be permissible, and it would fit within that box. And we were talking about that list that the court gave of the circumstances where the defendant could petition the court for that restriction to be removed. And in the Oakley case, there only was one time that they could come to the court and ask, and that was if the defendant showed that he was supporting his children. That was the only way that he could ask the court for that condition to be lifted. In this case, the trial court has given the defendant many options, not exhaustive too, because he said in any other reason. So some of those things that we were talking about are reasons he could come to the court and say, please let me procreate. And the court could probably give him that opportunity. Finally, with regard to the arrears order, we believe that this exact issue was addressed in State v. Morrow by this court, that it is permissible. In State v. Morrow, the court used the Jones test. It met the Jones test. It reviewed it under an abuse of discretion standard. We believe that the condition, as it is exactly the same as it was in the Morrow case, would pass that abuse of discretion standard. And the defendant's preference for the arrears to be separated out from what accrued during the period of indictment to what accrued outside of that period is really just a preference. It's not an abuse of discretion. Thank you, Your Honors.
Thank you.
I wanted to address the lifting provision because I do mention it in my brief, and I talked about it lengthy the last time they were here, but I don't know that I've addressed it adequately this time. And again, that is my position that these lifting provisions, there's not one other than, there's not one that Mr. Chapman can control other than the ones that are attached to financial well-being. And again, I would, it is sort of tied to my argument about the restitution being separated from the arrears in the order, because again, I disagree with the prosecutor that I don't believe that the trial court would, if all the children were emancipated, if all the children were adopted, there's still a restitution order that includes arrears, that he, we're talking, 20,000 here, 20,000 there, that the court would say, okay, because all of your children are adopted out or they're all emancipated, we're gonna forget the fact that you still owe that restitution amount, which includes the arrears, and we're gonna allow you to procreate. I don't foresee that happening, and I don't think that's reflected in the in the entry. You know, again, I think with that restitution being included with the arrears, even if all the children were emancipated or all of them were adopted out, he wouldn't even know what amount would be the restitution versus the arrears, and he would owe it all in order to be lifted from this provision and terminated from probation. Any questions?
Thank you both for your arguments. Court will take the matter under advisement and issue a decision in due course. We will make sure the clerk of court mails a copy of the decision to you on the day it's released, and the opinions are also posted on the Supreme Court Ohio website.